everyone. Thank you for taking a break from shoveling and joining us today. We are going to talk about how to navigate privacy litigation trends and the risks that are associated with those in 2026. That is this year. My name is Kirsten Thompson. I lead our privacy and cybersecurity group. My practice has both advocacy and advisory aspects, and today I'm going to lean into the advocacy side of things. I am joined by Emma Irving. Emma is co-leader of our National Class Action Group and partner in Denton's Litigation and Dispute Resolution Group in Vancouver, where there is no snow. She represents national and regional clients in commercial and regulatory disputes, including disputes about privacy issues. Then we go to the other end of the country, where we have Alexandra Quigley, also covered in snow, senior associate in our Montreal office and a key member of our litigation and privacy and cybersecurity groups. She brings quite a bit of expertise in privacy litigation and has appeared before numerous courts and tribunals across Canada. I also use her to do some advisory work in Quebec. She is my linchpin there. All right, so what are we talking about? Well, we're going to discuss emerging trends in litigation. When I say litigation, we're really focusing on class actions here. So a quick overview of class actions. Class Action 101. Class actions exist because they are big money. But you don't just go around, get to round up a bunch of people and decide to sue someone. First of all, there's a certification hearing, and that's a gatekeeping mechanism. You have to have a judge certify, or in Quebec, authorize your class action. It's a pretty low bar. You have to be able to demonstrate that you have pleaded your case correctly. In other words, there's actually a law that's been violated, that you have some kind of evidence to support your claim. It doesn't have to be a smoking gun, just to have some evidence. And whether there's an identifiable class of people and whether the class action is the best way to proceed. Certification is fundamentally a procedural step. It's not a trial on the merits. And to give you the difference, if you watch television or movie, they never show certification hearings. You go right to the trial, and that's where all the drama is. Certification hearings are just that, procedural. They're fun for people like Emma, Alexandra, and myself. They are less fun for TV producers and average people. Now, because you have to get through this certification or authorization step, that's really where all the, well, I'll use the term advisedly, excitement happens. If you are a smart plaintiff's lawyer, you pick Quebec or BC. That is the hotbed of class action litigation. Why is that? Both of those provinces have a very low bar for certification. The judges will practically let anything through. Now, that is changing, but typically almost anything that gets through will get through. And unlike the rest of Canada, which is a loser pay system, Quebec and BC are a no costs regime. So it doesn't cost any plaintiffs' counsel anything to launch a class action there. At least they won't have to pay costs. They have to pay their own costs, but they won't get dinged for the other sides. So that makes BC and Quebec very popular jurisdictions. That is why we have Emma and Alex on this call. That's where the class actions are being launched. On the privacy side of things, privacy class actions are pretty easy to certify, very hard to get to trial. Only one has ever proceeded to trial on the merits. Most things settle. Breach class actions are diminishing. It used to be the case that whenever there was a major data breach, a class action immediately followed. That's no longer happening. And that's as a result of two things. There was a trilogy of Ontario Court of Appeal cases in 2022 that essentially said, no, you have to prove damages. We have to see something other than mental distress. And that was for contract and negligence claim. The common law intrusion upon seclusion claim doesn't require that. But when you have to prove damages, it gets a lot harder to come up with something. BC Court then kind of went in the other direction. BC Court of Appeal 2 years later with two cases that pretty much found the same thing, but BC is unusual because it has a Privacy Act and it creates a statutory tort. And so those types of claims were permitted to proceed. So not completely opposite, but BC and Ontario are kind of heading in different directions. So if data breach class actions are on the decline, what is taking their place? And that is what we're going to talk about today. So what we're looking at now are class actions that are really focused on this nifty thing called consent creep, which sounds kind of dirty but isn't, biometric technologies, children's data, and post-breach contractual disputes. So we sort of stuck that one in there because it's technically kind of a breach issue, but it's more of a contractual issue. So let's turn to our first topic, which has to do with consent creep. Emma, can you explain what consent creep is?
Absolutely. Thank you, Kirsten. So organizations, as I think a lot of people will appreciate now, are required to obtain meaningful consent for the collection, use, and disclosure of personal information. The form of consent that you obtain can differ depending on sensitivity of the data, the risk of harm to the information, but it's also important to tie it to what you are going to be doing with the data or who you may be sharing the data with. And it's key to keep in mind at the end of the day, if you don't have consent for what you're doing with the personal data, then it's an unauthorized use. You're not using it properly. And what we are seeing, and we expect to see more of these in the class action world, is questions regarding whether or not consent was obtained, but even if it was obtained, was it sufficient for the circumstances and what the party was doing with it? And consent creep is one of those things where you may have had consent to collect the data in the first place. For example, you get consent to collect information regarding people's birth dates and their emails. But the consent that you obtained from the person when you collected the data was to do one thing with it. And it was maybe to provide some promotional materials or, but it's limited. And then whether it's intended at the time you collected or not, down the road, either that organization decides there's something else they could do with the data and they start doing that, or they disclose the data to a third party, perhaps for very legitimate use, but that third party then starts doing something with the data. Those uses you never got consent for them. They didn't fall within the scope of consent that was given. So that's what we're calling this consent creep. And I said it can happen both when an organization uses data that they legitimately collected to start with, or when they give it to a third party and that third party uses it. And it's important to remember, if you're the party who collects the data, is the custodian of data, and then you disclose it to a third party, you're ultimately responsible for what happens down the road with the data.
Yeah, that's the service provider provision under the privacy laws. So the way to solve that is to, I think, to align you have to look at your contracts and make sure your restrictions align with your original uses.
Absolutely. And making sure that you're not just going and clicking standard terms of service to any service provider such as Facebook or Google that you then go and give your data to. You might think that it's just you get your contract, and Facebook, Google, those technology companies all have standard terms of service, but if you look at them, they're actually very broad in what they can do with the data. And there's an example that we have at BC recently where there was a case involving Flow Health. Flow Health developed a period tracker and had collected very sensitive health data from women. And their privacy policy was fairly restricted in what they said they were doing with the data. They said they would only share the information if it was reasonably necessary to perform their work to help understand and improve the app. But what they did was they then entered into agreements with third-party data analytics companies, including Facebook and Google, and shared that personal data with those third-party vendors. But in doing so, they simply accepted Google's and Facebook's standard terms of service. And those terms of service said that those third-party companies could basically do whatever they wanted with the data they received. And ultimately, this resulted in a class action lawsuit being brought against Flow Health. And so it's a case where they collected the data with consent to collect it, but they didn't have consent to give it to third-party data analytic companies and let them do whatever they wanted with the data. And so that's how they got into trouble there. And they weren't checking the flow through of the data in their service providers.
So this means you have to look at not only your own contractual clauses, but also your privacy policy and any consents. So those pop-up consents have to align with what you're actually doing. Alex, is it the same in Quebec?
It's similar. I think where we're seeing quite a bit, and then why we often encourage organizations to look within, is very sort of popular language that we're seeing in privacy notices, where organizations will commit to reaching out a second time to their users to get valid consent should the purposes change for which they're using that personal information. And so if you are undertaking to do that, you have to keep that in mind when you're coming up with these nifty uses or secondary uses for your personal information. Always go back to what you're doing in the first place. We also have unique provisions in Quebec that have to do with consent and the use of personal information for things like geolocation, for profiling, which covers very frequent uses for personal information, and those will require an opt-in consent. So be very mindful when you're looking at that, even though that can be very interesting, both from the organization that initially collected the personal information, and then especially if you're looking at a service provider, be very careful when considering those uses because it may not align with your initial consent, and those need to be valid and should be looked into closely by an organization to avoid issues down the line.
So a nationwide consent pop-up or a nationwide privacy policy might not cut it in Quebec. That's what I'm hearing.
Not in everybody's favorite province when it comes to privacy.
Well, and the other thing
Oh, go ahead, Eva.
I would say the other thing I'd say there is, at the moment, Quebec might be an outlier, but this is an active area of legislation. A number of governments are looking at this, and I think we're going to see developments in the regulations over the coming years. So it may be that right now you've got to be more careful if you're operating in Quebec, but it's something I think you're going to have to stay on top of and keep updating. Because not only is, your use of the data might be changing and it might require you to get a different form of consent, but when you collected the data, it might have been fine under the regulations, but depending on how they have evolved, you might need to go back and get a different form of consent if you're continuing to collect data and use it.
Right,
and consent
it's a good time to point out too that we've been talking about regulations and statutes, but the common law has a similar concept of consent, and so what you're seeing under PIPEDA, the provincial laws, is a good sort of guideline to understand what meaningful consent is, because consent that is not understood is not going to hold up in court.
Mm-hmm. And consent awareness is key when you're looking at regimes that are either consent centric or, rely on it heavily. It's always better for your organization and your decision makers to be aware of that.
Yeah, something I've seen is if whenever I get a new client who wants me to work with their privacy, first thing I do is go to the privacy policy. If I see it hasn't been updated since 2018, I know they have a problem because surely they're doing something that they weren't doing in 2018. That is also a really easy tip-off for plaintiff's counsel. So if you have not updated your privacy policy recently, you might just want to noodle on over to your website and see just what the date on that is.
And it's not worth trying to be kind of cute about what you're doing with the data. The more you can be express if you've got a particular purpose you're going to use, because even if you end up at the end of the day convincing a court that you were sufficient, that doesn't mean you've avoided the lawsuit. And you can be sued in any case, but even still, the higher we're seeing in some cases higher settlements too when there's something, it's arguable whether or not what you were doing was actually provided that kind of really express consent for something that you knew you were doing with the data and people might have objected to.
Yeah, and you'd mentioned the getting a second consent. So for instance, privacy policies say, here's the way we're going to use your information. If we do anything else with it, we'll get additional consent. In some cases, the additional consent can be simply an amendment to a privacy policy for non-sensitive personal information. In other cases, it's going to involve an active reach out. I'm sure you've all seen things with, hey, we're updating our terms, and there's a pop-up. Click here to see our privacy policy, or click here to consent to this new fancy use. So we're probably going to see more of these types of pop-ups as an attempt to refresh consent or get new consents. Some of it is required by law, arguably. Others is to defend against sort of scope creep and make sure that what you're telling people aligns with what your new practices are.
And to that end, maybe encourage open lines of communication between those that are drafting and updating your policies, your legal department, and who is coming up with nifty ways to use that data. internally, both because perhaps this will help avoid a headache immediately, and also you want those open lines of communication if there is litigation to understand what's for and what the purposes were. So sooner the better.
Yeah, Alex is being charitable. I'm going to call out everybody in the marketing department right now. Probably the number one scope creep is the folks in marketing who have all sorts of analytics software, all sorts of partnerships, all sorts of user engagement, all sorts of analytics. They want data, they want to use data, they want profiles, they want insights. If you're not already walking down once a week to have a coffee with the marketing folks, I suggest you start doing so because these things move quickly. And if you don't understand what's going on in the back end, there's no way you can protect the organization on the front end at the user level.
And it may be that they, it hasn't even tweaked in their minds that they're actually even processing or using personal data, and particularly that they're not. The one that sometimes occurs is they've given what they think is anonymized data to a third party, and they've disclosed the data, but the question can arise, is it truly anonymized? Are you still disclosing personal information? And it may not even occur to them that they are actually doing that. And that they are disclosing data to a third party who's then going to process it on the back end. And you may not even know that the third party is doing it. It may not be part of, what you'd signed up to do. An example could be you've got a company who you've given some data to, and it could be employee data, so that they can do some processing for you on the end. And that's, that might be fine. But if that third party is collecting data from 10 organizations, and then they decide that they're going to try and use that collection of data to create some AI feature or something else, what's being done with the data can change. And now maybe it's being disclosed and they're actually using this personal data. So it's important to have those conversations with what exactly they're doing, because they may not actually realize if you just ask, hey, are you giving out personal data?
And be wary. I'd say don't take an easy no for an answer, because we've heard countless times, you have any personal information? No, it's almost never true. No bad intent, just misunderstandings, but ask a second question that's worth it.
Definitely.
Yeah, and a good guideline is your privacy policy is probably your front line along with additional consents. You will never learn your privacy policy as well until you get sued, and then you will learn every single line of that. I guarantee you that will be Exhibit 1 in the plaintiff's claim that says you failed to get adequate consent. So think of it from the perspective of a consumer or a user of your products or services. Take a look at it. Can you honestly say that this is meaningful consent? Are they going to understand things? There's a tendency and a tension between, oh, we don't want to tell people what we're doing because, they'll get scared of all these scary things that we're doing, versus let's just tell them what we're doing. And I've got to say, most of my clients, probably about 80%, pivot to whoa, we better not use those words. Somewhere in there has got to be a happy medium. But you may be trying to play hide the bunny, and that will come back and bite you if you get sued. And I will say that plaintiffs' counsel do look at these things. The equivalent of the privacy commissioner in the UK, the ICO, developed a handy little bit of software that crawls the web and then rates not only cookie banners but privacy policies. So they've automated that. So if it's going to happen there, it can happen here. That'll get you into regulatory trouble, but usually regulatory trouble can lead to a class action. All right, that's our consent creep, now that you know what it is. And all of you who are tuned us out are now flipping over your website to your privacy policy. Let's now talk about biometric technologies. So biometric technologies are technologies that use human measurements that are connected to an identifiable individual. This has been a problematic area for two reasons. One is the technology is moving very rapidly. It solves a lot of problems, and it solves problems relatively cheaply. Notably, commercial infrastructure, large crowds, large gatherings in public spaces, very good for biometric technologies. Crowd control in arenas, for instance, early response and prevention. Retail is adopting this very quickly, mostly for loss prevention and conflict, violence avoidance, or deterrence. So we're seeing this explode in Canada, and in part because it's now accessible, and lovely AI can use facial recognition and software in cameras and all sorts of things, voice recordings, it's all over the place. A lot of the companies that make this are US based, and so they have very different considerations when these products come to Canada. They often aren't really aware or don't comply with Canadian privacy laws, and we have hapless retailers or infrastructure people that just roll these things out with really not thinking through what they're doing. The other piece of it is on the regulatory side, we have some not very helpful guidance from the privacy commissioner that is just biometrics are pretty much any human measurement, whether or not it's identifiable, which means pretty much everybody is offside the law. So it's not particularly helpful. And then Quebec's privacy law and their IT law actually address biometric information specifically and regulate it in a specific way. And we're already starting to see an uptick in some litigation and regulatory fallout from that. Alex, why don't we start with you on the Quebec situation, since they actually address it directly. What's the litigation landscape there?
It's actually quite interesting for the litigation landscape because just to go back, there are specific requirements for biometrics in Quebec, specific consent requirements, but also notification and sometimes registering with our privacy commissioner ahead of time. So this is a risk in the sense that this could trigger quite a lot of interest from the Quebec privacy regulator and have you easily be exposed to fines and consequently contractual issues if you either promised that something complied and did not, said that you were compliant with the requirements and you haven't declared your use of biometrics and so on. You could easily be in a tricky situation there. It's also a bit of a scary situation. If we talk biometrics, you imagine that scene where they're using your retina in some spy movie, and everybody gets concerned and is quick to file. But it can be something like crowd control, surveillance, and so on. What you want to do is ask questions. That's usually when things will fall apart, either from the person trying to sell you the tech or from the person who's already purchased it. You have to be careful with those elements. Watch out, understand what you are collecting and what you're using it. Also, what you're using it for, excuse me. And also what you want to see is usually where we have those safeguards and where the commissioners will be somewhat reassured is when you have a human factor. Verification, checklists, double checking. That's not usually in the marketing materials. That's not usually what will have that technology be interesting. So they'll talk about AI, they'll talk about speed, about lower costs and so on. But if you dig in and you actually understand the product, that is going to be your best element of defense in case of regulatory verification or in case of litigation.
Yeah, and it's a fairly poor regulatory understanding of biometric information. And I'm going to mention that because generally speaking, the privacy regulators in Canada find this a really cool and sexy topic, and so they rush to publish these reports. If a report gets published that alleges you're using facial recognition, there's a high probability you're going to end up on the wrong side of a lawsuit, a class action. But the reality is there are very different flavors of biometric information. There's a difference between, say, face detection and face recognition. So make sure you understand what technologies you're using and how you were using them. And we've seen that in some cases that have gone forward where in a couple of cases, notably one in BC, where the dispute was the company saying, no, this is just face detection, plaintiff saying, no, it's face recognition. And it's now before the Court of Appeal. But the issue there is really fundamental. Is it personal information? If it's face detection, i.e. that's a face, I'm going to count one, that's a face, I'm going to count two, or that's a person that's entering this place, but I don't know who it is, versus true facial recognition, aha, this is a bad person, Alex, and therefore we need to escort her from the store. Those are two very different technologies. The underlying technology is very similar, but how it's used is different. So in that case, if you're doing your privacy impact assessments and you're assessing this technology, make sure you drill down on what it is, because it's a very quick way to short circuit a class action lawsuit on a privacy complaint if what you can say is, look, there is no personal information here. And the technologies are now sophisticated enough that you can credibly say that this isn't an either or sort of a squishy middle. It really is an either or.
And I think to do that, you need to find the right people to be able to explain it to you and to either the court or your regulator and so on. Because this is where you want to be careful between someone who really understands the technology of it, on the one hand, that's key, but is also giving a factually accurate and neutral description of it. Okay, you don't want someone that's upselling your product and saying, we can identify anyone, we can identify Kirsten and only Kirsten in a sea of 2,000 people, and we keep everything and it's automated and there are no safeguards, so it's cheap. That is not the message you want out, and not, say, a sales pitch you'd want to be contradicting once you're before a judge.
And when you are examining this, then the class actions are just starting to look at this. In the common law context, it starts with the concept of what is a reasonable expectation of privacy. You have more privacy in the privacy of your own home. You have less reasonable expectation of privacy in a shopping mall or a public space. So where it may be okay to roll out, say, the use of facial recognition in a public square, where there's for crowd control or anti-terrorism purposes. It probably won't be acceptable in a small retail environment. I love my clients who say, but so-and-so's doing it. Why can't we? I love that because you never have the facts that the other guys did, or the other guys just might not care. So really consider how you are using this. Pay attention to the case law as it develops on this, because we're starting to see more and more of these examples come forward. For instance, the Vancouver World Cup, they're rolling out CCTV cameras with facial recognition. We now see it in many large public areas, arenas, malls, that kind of thing. Those are mostly public sector regulated, but still ripe for a common law lawsuit or class action. And then, as I mentioned, seeing it in retail environments quite frequently.
And the thing to remember is, class actions, whether you win or lose at the end of the day, they're quite expensive. So this, technology that someone's coming to you with to say, hey, try this out, might sound, oh, that's really cool, let's try that. But it's worth thinking through, because even at the end of the day, if you're successful, and if, as we said, if you get sued in Quebec or BC, you're not going to be able to recoup your costs. Even if you get it struck out early. So there are real consequences to not, taking that pause and thinking about it and being careful. And, as Kirsten already said, like BC is a hotbed right now. We have plaintiffs lawyers, looking for these class actions and looking for companies that are misusing data. And so it's getting entangled with one is a lengthy and costly process.
Mm-hmm. And to your point, Emma, there are different regulators across the country that have not been impressed or satisfied with, oh, well, they use it in the States, or so and so is doing it too. So it is worth looking into, putting the work, have you had a case study? Do you have evidence or data to back up a real need for it? It's worth looking into and putting some money or time upfront to avoid how much it can potentially cost you down the line.
Yeah, and along those lines, limit your risk. If you think this is justified and you think you're going to use it, and you have this new whiz-bang facial recognition thingamy that you're going to mount over the doors of whatever it is business you run, maybe start it as a pilot project first. And therefore you limit your litigation exposure to, say, one or two locations in Ontario versus all of Quebec or all of Canada. So start with a pilot project. Pilot projects still have to comply with the law, but you will limit your exposure.
And beware of those sales pitches. So, for example, we've heard of situations where company X offers tech that can have facial recognition features if you enable them. And yes, they've sold, thousands of those devices across Quebec, for example, but then we find out that none of them are enabled for facial recognition. So when you have those pitches that say, it's fine, thousands of those have been sold in Quebec or across Canada already, double check, because if that's all you're relying on and the extent of your due diligence, it may hurt when this comes out in litigation.
Yeah, and if they can be enabled with the flip of the switch, make sure you know who can flip that switch, and maybe keep a close eye on them. All right, on to our next topic, which is children's data. Children's information is a big thing. Anybody who listens to the webinars we do, our monthly webinars, knows I have been banging on about children's data and children's privacy for many months now. And the reason I'm doing that is partly because I don't think Canadian organizations are taking it quite as seriously as they should. Not something you'll usually hear from me. But Canada has lagged behind what we're seeing globally. There's outright bans of children on certain platforms, particularly social media and certain gaming. There are age verification, age gating, age authentication type mechanisms which use facial recognition in some cases. I will leave it to you to decide which is the more insidious application. So we're seeing this take off all over the world. Everyone is concerned about children's privacy. The vast majority of my clients shrug and say, well, we don't collect children's information. The problem with that is that you have no way of proving that if you haven't been able to turn your mind to it. And I've now worked with 2 clients who said, we don't collect children's information, only to find out they actually have quite a bit of children's information. They don't do anything with it, except they just lump it in with everybody else's information and process it the same way. That will immediately put you offside where the law is going on this, both privacy legislation and common law. Probably the 2 biggest growth areas in privacy litigation at the moment are in biometric types of information and children's information. We're starting to see that. Let's start with what we're seeing in BC. Emma?
Yeah, absolutely. So what we're starting to see is class actions that are targeting companies, particularly social media type companies where they've got an app, or gaming companies who are collecting children's data in some way. And to start with, children's data, even if it's the same form of data that you would collect from an adult, it's just inherently more sensitive when we're talking about children. This is a new and evolving area, and so there's still a lot of open questions, and that's part of what we're seeing the courts are starting to have to grapple with. There's very little regulation and be specifically on children's data, so the courts are looking at this, and they're having to deal with questions with regards to consent, who can give consent for collection and use of children's data, how far can that scope go, and how informed it has to be. There's a recent case that was actually filed late last year against TikTok as an example. And so TikTok had said publicly that their platform was for children and adults, but children 13 and up. But one of the allegations there is, leaving aside for a second that 13, 14-year-olds are still children, they actually have no way of proving that they're verifying these ages. So they're saying, they were not targeting children that are under that age, but there is still evidence, and the named plaintiff is actually under 13, that children are still using it, even if you're not targeting towards them. But in that case, the claim actually follows off of a privacy commissioner investigation that alleges that TikTok collects, uses, and shares users' data, which includes children's data, including information collected through users' browsing activity. So you see the videos, and they would like videos or share videos, and that the data as to what types of videos children were liking and sharing was being collected. And then TikTok was using that data to target ads at the children. As adults as well, but this case is particularly focused on the issues with children. And TikTok's terms and conditions state that they can do this, but the allegation they claim with respect to children is, one, that TikTok doesn't take any steps to verify a user's age, and then when they have children, to obtain parental consent with respect to the collection and use of the children's data. And in particular, they're pointing out the harm with respect to these targeted ads at children. This action's in the very early stages. We don't know how it's going to play out, but it's an example of the types of claims that we're starting to see in BC revolving around the use of children's data. And in a case where, it's a social media app, adults and children use it they're collecting data in the same way. But the question is, even if your consent is valid for adults, what are you doing when it comes to the consent and the use and collection of the children's data in particular?
Right, and we're starting to see globally that even certain uses of children's information are now outright prohibited, targeted marketing being one. Quebec is actually further ahead and has been for several decades around its advertising to minors, but it addresses children's information specifically. Alex, what does Quebec have to say about children?
So
Children's privacy, not just children generally.
amongst other things, so children under the age of 14 cannot give valid consent themselves in Quebec. It has to come from someone with parental authority. 14 and up, it can be someone with parental authority or the child itself. But again, this is in conjunction with very specific and extensive consent requirements in Quebec, which would likely be interpreted in a very strict manner when it comes to those children. So similar to what Emma pointed out with the TikTok matter, which is how are you actually verifying? How are you getting that parental consent? Or how are you making sure that it's coming from parental consent, not the child under 14? What does it look like? What are you using it for? Going back to that consent creep earlier, I would say double check when it comes to children's data, because that will likely be interpreted in a very strict manner by your privacy regulator or the court if you're dealing with a class action. These types of issues have to be looked at, because then those strict requirements in Quebec about how to obtain valid consent, which is giving them the information that is necessary for them to consent, how are you going to do that with a child under 14, or even, you still have to look at it there, because you aren't able to assume that it's being given by an adult for someone over the age of 14. So you want to be able to grapple with all of those and have the necessary evidence as to your compliance in case of litigation or regulatory intervention.
Right. And if you are a company that believes you don't use children's information, you need to childproof your organization. Lock the doors, tape up the windows. No, I'm actually talking about your website
Those
and
little lock
products.
things that you can't use, the childproofing.
Childproof cabinets. If you do not believe that you use or collect children's information, how are you going to demonstrate that? Have you audited your holdings? Do you have any way of understanding what information you have? Is your product or service, and I don't mean to besmirch our clients on the call, is it an attractive nuisance to children? In other words, you might aim it at adults, but kids love it, and so you have a certain percentage of the population that is under the age of 13 or 14 or 16 and is on your website. I had a conversation with a financial institution who just blew past the children's privacy parts of the questionnaire. I was asking them, and now we're a financial institution. We don't do anything with children's information. Well, 3 weeks later and several interviews later, it turns out they have children's accounts or youth accounts. So they do. So maybe have a walk around your organization and find out what you're doing. And if you are convinced you don't have children's information, then you're probably okay. But how are you going to demonstrate that? And this is honestly, in the last couple of months, I have done this. Oil and gas, not something you would think has children's information. Many of them sponsor charities, sports team for youth. They do have children's information. So children's information is everywhere, frankly. So make sure you know what you're doing with it, because if I am plaintiff's counsel sitting on this is pretty easy to monetize in a class action. And the optics of being besmirched with headlines that say you've misused children's information, it's not a good look.
And an audit or look towards your marketing departments first, for example, because if you've been running marketing campaigns to say, I don't know, offering your services to teens or students or so on, you don't want to be in an awkward situation where you say, we don't deal with children's data, and bam, this is the first, the second exhibit that's going to be filed in the lawsuit. So even if it's informal, as Kirsten said, I think you'll discover some children's data fairly quickly, even in the context of an informal audit.
Yeah, and just knowing what I know about the folks on the BC Plaintiffs Bar, I would expect we're going to see a significant upswing there. And I particularly the holy grail, if you're plaintiffs counsel, if you can get biometric information of children, that is going to, I said it here first, 100% lead to a class action. And how can this happen inadvertently? Think of those phones, devices, everything you use that do facial recognition, face detection, all those fancy filters and things that you put on or may use, the virtual trying on clothes, all those sorts of things have the potential to combine biometric information with children's information and get you into a whole whack of trouble. All right, now that we've scared everybody, um, let's go to a dry topic, post-breach contractual disputes. So this is when there has been some kind of business transaction, a merger, acquisition, sale, some sort of thing. Everybody hugs, it closes, they feel pretty good about themselves, and then a data breach happens. That is the only time everyone will go back to the contract and actually see what everybody agreed to. Most of these things just live in drawers. So what's going to matter are things like liability caps, indemnification, when did it happen, whose watch did it happen on? So what happens once the deal closes? Emma?
Yeah, absolutely. And it partly depends on obviously what kind of transaction. Here we're primarily talking about a share transaction. So you've acquired the company, not a pure asset transaction. But even with an asset transaction, be careful depending on what assets you're actually buying. Did you buy technology in particular? Did you buy, data in a sense? So be still careful with asset transactions. Like a lot of these provisions, you think of them for share transactions, but you still have to be very careful when you're doing an asset transaction, think about what are you actually buying and what are the limits on liability both ways. So, I mean, absolutely, if a breach happens after the transaction closes, unless you're talking 10 years out, the first thing is looking back at the contract and what did people agree to. You're going to have to figure out when the breach occurred, but also what caused the breach. Was it a weakness? And what was in the disclosures? What were the scope of the disclosures and the representations and warranties? The thing to watch though, like even with an indemnity clause, like you could put in a great indemnity clause and, not to discourage that we're definitely, suggesting you be very careful with drafting. But when you're doing this, you also have to think through the realities of implementing these. You can have an indemnity clause that says if the breach happened pre-transaction, the seller's on the hook. But does the seller actually have any assets at the end of the day? Or has all this been distributed to shareholders? If you're the big pockets, you're the company buying the smaller company and you've got the big pockets, you still very well are likely going to be sued. You're going to be the one who's going to have to defend. You may even pay out the settlement. It'll be up to you to try and collect back. You can't just point to the indemnity or the limitation of liabilities clauses and say, we'll go after the old owner. That's not going to cut it in court. You're going to be the ones who are going to be trying to enforce those contractual provisions. And so it's at the end of the day, it's going to be a matter of negotiations between the parties. But you need to think at the front end, two parts. One, due diligence, being careful with the due diligence, but also thinking through what are the possible risks and what is your risk tolerance and what are you trying to capture between either indemnity clauses or limitations of liability. As the seller, you're going to want to put a limitation of liability in. As the purchaser, you're going to want to be careful. But you really do need to be careful with respect to figuring out when the breach occurred and who's on the hook. And in order to avoid basically a second fight with respect to who is on the hook, you want to think of those at the time of the transaction and make sure your contract is clear as to who is responsible for what, depending on when something happened. And there's an example that happened recently with Marriott hotels. They bought another hotel chain, and the transaction closed, I think, in 2018. There had been a breach in the system already, starting in 2016 or 2014, and the hackers were already in. And so the hackers had already got into the data system when the purchaser took over the company. And then 2 years out, it's discovered, and there's a privacy commissioner investigation, and there's lawsuits that follow. And it's the company Marriott that ultimately purchased the smaller company who's now having to deal with those fines and having to fix it. Now, some of that may have been avoided through properly drafted contractual provisions, but ultimately it's the due diligence on the front end that could have caught it and could have dealt with it.
Right, and these get really messy because not only are you fighting amongst the parties, assuming the selling party continues to exist in some form and continue to have assets. So you're trying to enforce a contract as between those two parties. And then there is, particularly in this case, the hotels and others, large quantities of personal information. You are then, one or both of those entities will then face class action or class actions, plural. Which you then have to sort out. So these things can be messy and live on for a decade easily.
Yeah, you want to be careful when we're talking about, how far out the indemnities go or the representations and warranties. You're thinking in years, not months.
Yeah, and due diligence is getting better. I've got to say the transactions that have come across my desk, they're more rigorous. Interestingly, I've yet to see any due diligence questions about children's information. Starting to see questions about artificial intelligence, automated decision making, biometric information, those sensitive things. Haven't seen any about children's information. So you may want to consider a rapid warranty about we do not collect if you're on the one side or the other of that transaction. Again, this is sort of an emerging area. I will also know from my breach work that besides Black Friday and sort of the Boxing Day, Cyber Monday breaches, because that's where the bad guys target these things, the number one or number 33 popular time for a ransomware attack or other incursion into somebody's systems is just after an organization closes a deal, particularly if it's been made public. Bad guys are no fools. They know that that is when transition is happening. People are understaffed. People are on holidays. There's been layoffs. It's general chaos. Not a lot of controls. The controls get lax. And so that is when the bad guys will make an attempt to get into your system, and they will probably have more success than they would have if they had tried previously. So we're starting to see more and more litigation around sort of who's on the hook post breach.
Transactions are also very busy times, and it's easy for privacy to be one of those things where you want a checklist of, do you have a privacy policy? Sure, check. But because we are seeing more and more of these issues are rising, it's important to actually critically look at that aspect of the due diligence. It's not just a checkbox, and there can be some early red flags. For example, if they don't have a privacy policy, that's a big red flag. What are they doing around privacy and data? Or if their privacy policy is 10 years old, well, that's clearly out of date. But also if their privacy policy is a month old, is it a month old because it's their updated one, or did they just develop it a month ago?
Or did something happen that led them to do it as well?
Yeah, absolutely.
Red flag.
And so you want to be pushing on some of those questions. If there's something that feels a little off, just push on it, because these can come back to haunt you at the end of the day.
And speaking of haunting, also think about those trustee service providers that you were working with either for years or that you worked with a few years ago that maybe still have some data, or sure, you figure you have those contractual protections. But like Emma said, if things happen, they're going to go for the big bucks and they're going to go for the big names. And you will be triaging or trying to figure things out as to who is responsible based on those contractual provisions afterwards. So be mindful of, yes, perhaps you listen to Kirsten and Emma's great recommendations and you've updated everything. But when you were using those cookie cutter provisions a few years ago, you still exchange some data with some service providers and could be looking at some issues in case of a transaction or otherwise.
All right, let's move now to the questions. There's an interesting one here. I've been concerned about our use of American cloud-based software. They assume as our data is held in, they assure us our data is held in our Canadian cloud, but I wonder if they have access to the Canadian cloud version of their software. Any comments on this? That could be a whole other webinar. Everyone talks about the cloud, but no one knows what it is or where it is. So if you're signing off on cloud provisions, start becoming very familiar with terms. Sovereign cloud is a big one making the rounds right now. What does it mean? What is the difference between storing your data, processing your data? Where is it and where will it be? Now, most of the major cloud providers usually have a Canadian instance, but you need to figure that out. Most of those Canadian instances means the data lives in Canada, but probably is accessed by IT support people located elsewhere, usually the US, sometimes India, Philippines, quite common. I have not seen a class action based solely on the location of the information. I have seen class actions where essentially a claim of unauthorized access or unauthorized use has been made on the basis of the fact that the location of the people who had access to the information was not disclosed. That's why you often see in privacy policies that sort of boilerplate phrase that says, we may use service providers located outside Canada. So that's why that's there, so people are on notice. It gets even trickier in Quebec.
Yes. And with health information as well. So I've
Yes.
seen it not in a class action context, but in a regulatory context with health information, sensitive information, health adjacent information, or kind of hybrid information. There are some quite stringent obligations, especially from professional orders, quite a bit in Quebec. So we're thinking dentists, pharmacists, healthcare providers, and their service providers are often looped into those as well. So there we have quite a few concerns on that. And a lot of those regulators, not just the privacy regulators, expecting both the individuals and the companies that they are affiliated with to understand what is happening with those cloud services. So not a cookie cutter answer for you, but commending you on your reaction to look into what's happening with those cloud services.
Yeah, we do see every now and again litigation that is based on, well, you didn't have meaningful consent because had I known you were going to store this in the US, had I known you were going to have people in the US looking at my information, well, I never would have consented, so my consent is not meaningful or valid, therefore pay me money. So starting to see that, have not seen that in a large context, like in a class action, do see it fairly frequently, and especially now, given the political environment we're in, starting to see this bubble up a little more often mostly in small claims court and smaller actions, $10,000. It's usually looking for money or, free product or service. But they're happening enough to be annoying. I've recently had to go to small claims court on one of these, and I haven't been in small claims court in years, decades. I will say it, decades. So you probably don't want to be on the receiving end of that. So it's fairly easy to just put a disclosure in your privacy policy. I'll just remind people that the questions bar is open. So if you have a question, please type it in there.
And not really the answer, there was a question about best practices when it comes to genetic testing as well. But for that, with the Quebec perspective, but I would say anywhere, consider looking beyond strictly privacy laws. So for example, in Quebec, we have health information laws that double over some of our privacy laws, whether they're private sector or public sector, but also have their own provisions and requirements. Consider the ethics obligations, so the code of ethics for whatever profession or specific profession you belong to, or that those you are working with belong to as well. So those broader analyses are essential when it comes to this to make sure that you're compliant.
Okay, I think we are through the questions. Last chance if anybody wants to put something in there. People furiously typing. I don't see any activity. So thank you everyone for joining us. Certainly pay attention to this area. As I mentioned, I expect that we will see probably a flurry of class actions and litigation around the topics we've discussed. Please do your best to stay ahead of them or give us a call if you're not. Hope you found this informative and filled with practical insights. We try and do our best on that. If you have any questions or would like to explore how these issues apply to your organization, we're always happy to connect. You can find out more on our Debt and Stata blog. And we also have a commercial litigation blog. You can find more stuff there. And thanks everyone for joining us.